All right, welcome back. Good evening, everyone. We are on voting list number 3. Today's Thursday, February 12th, 2026. We have, how many bills on this voting list? All right, is everyone squared away with voting list number 3? All right, Jamie, we'll start off with you with Senate Bill 74.
Senate Bill 74. Let me pull that up.
Oh, shoot, I don't know. Okay.
Senate Bill 74 is a departmental bill that repeals the requirement that a police employee or deputy state fire marshal in the Department of State Police on promotion be entitled only to the pay specified for the new rank and the next lower step than the police employee or deputy state fire marshal occupied before promotion if the step that the employee or deputy state fire marshal occupied before the promotion. So basically, if somebody's been there the same amount of time or longer and is in equal rank, they don't actually have to lose a step to go into the new rank.
This is like kind of a, yeah. I'm gonna ask you that. All right, there's been a motion for a favorable. It's been seconded. Do we need a roll call, or is everyone okay being recorded in the affirmative? All right. Just keep on. All right, Senate Bill 74 passes unanimously. We're now going to move on to Senate Bill 82.
Uh, 82.
No, you're next.
Senate Bill 82 adds leases and rental agreements to the list of documents subject to the prohibitions and penalties pertaining to counterfeiting of private instruments and documents. There's one amendment in your voting packet. The amendment is Amendment 263-127/1, and if you go to page 2 of the reprint, after lease, it says lease of real property, and then again down to line 10, for rental agreement, it says rental agreement relating to real property. So it clarifies the application.
I'd like to adopt a motion to adopt the amendment. Second. Is everyone okay adopting the amendment? All right, now the bill's before you as amended. Open. There's been a motion for a favor. Oh, hold on. Open for a favorable. It's been seconded, but Senator Sidnor has a question.
No, I mean, there was concern that was expressed by the Public Justice Center with regards to the whole possession of a fraudulent lease or rental agreement kind of capturing occupant victims. And I don't know how we make. I mean, I'm assuming that's not what we're targeting with this legislation, but I'm also not certain how one addresses that.
It's lines 16 and 17. It's not mere possession.
With intent to defraud another.
Right. So, would you like me to read it, Senator? So the bill, the existing statute does provide that the prohibition is a person with intent to defraud another may not counterfeit, cause to be counterfeited, or willingly aid or assist in counterfeiting any, and then list the list of the documents. But as to the possession, which is also prohibited, if you go to the next page, lines 14 and 15 on page 2, that prohibition is a person may not knowingly, willfully, and with fraudulent intent possess a counterfeit of any of the items listed in subsection A. I guess is my understanding the question is if you have somebody who innocently is occupying a building, they've been defrauded just as much as the owner of the property has been defrauded. They're just both unknowing about it. Would this prohibit their possession of it? I can't imagine a situation where that person who's innocent in that situation would meet that definition of knowing, willful, and with fraudulent intent. Right, I obviously just pointing that out to the committee.
And the purpose of me even raising the question, I agree, but I just wanted to make certain that this is not this committee's intention is to go after people who were defrauded themselves. And I'm just trying to make the, all right, then I'm good. I just wanted to make certain it was for the record. That's not who we're dealing with. Thank you.
I hope that is enough to withstand for a criminal defense, a comment made at a voting session that if a person is standing before a court, that they could use that as a criminal defense. But it looks like one of the notes I have from the hearing is that this section is used for documents that are recorded instruments. So it's easier to discern if it's fraudulent because you would have a recorded document that is the authentic record. So you could presumably compare what the person has in their possession to the recorded record. And then the court could then, based on the standard of proof, determine if what they had was fraudulent or not. If we're talking about a lease that someone has and you're trying to determine if it's fraudulent to a standard of criminal culpability, and that lease agreement is not required to be recorded, I'm wondering if we'll run into some sort of standard of proof or if the trial is just going to be the Wild Wild West. He said, she said, you're alleging that this is a fraudulent lease. They're saying it's not a fraudulent lease. This is a section where everything else is a recorded instrument. So I don't know that we're posturing this for the best or cleanest prosecution in comparison to everything else that's listed there. May I raise a second point, Mr. Chair? I also have in my notes that it says lease, but it doesn't say real property lease. You could lease. Oh, that is an amendment? Okay, great. Perfect. But yes, still understanding that if we're looking at the other ones, I think that sort of liability would be more appropriate if we had something that was an authentic record that could be compared to it. Whereas if we're just making a standard of fraudulent lease and we don't have an authentic record that we're comparing it to, it seems like the standard of proof issue is going to be difficult to discern. So understanding that, for that reason, I would have a difficult time voting yes on this bill, but that just gives context to my vote.
Thank you, Mr. Chair. So there are lots of other 603-8-601A lists a whole bunch of things that can be counterfeited. Very few of those recorded. Deeds, I guess, would be recorded. But I'm looking at all the other ones. You've got promissory notes, negotiable instruments, letters of credit, entries in account books. I think what we're going after here are these terrible situations of squatting. And every day there's more stuff. I read another article on the front page of the Baltimore Sun this morning about someone who was in Montgomery County, who was arrested, tried, convicted for squatting, put in jail, gets out of jail, goes right back to the same house and breaks into the same house and squats in the same house a second time, always alleging that they have a valid lease. It's a serious problem. So I would suggest that trying to require the lease to be recorded, leases are almost never recorded.
If you compare it to the other documents, power of attorney requires 2 witnesses and a notary. If you compare it to a will or a codicil, 2 witnesses and a notary, and an attestation that the person is over the age of 18, they're in their sound mind and body. If you require it to a mechanic's lien, has to be recorded. A title of a motor vehicle, it's registered with the Motor Vehicle Authority. If you require to the lease or discharge of money or property, also another duly noted and notarized instrument.
Not
If you look
always.
at the other things that are listed there, these are things that have some sort of verification, witnesses, indicia of authenticity that you are using them to say, this is my official record, and this is what the person has presented as a fraudulent record. So if I'm the trier of fact, I have something to look at in comparison to. If person just presents with a lease and you're trying to figure out, is this real, is this fraudulent, is this whatever, if you have nothing to compare it to that has any sort of indications of what it should or should not be, I just think it's misaligned with these other things that are so easy to verify based on the standards that we've put on them. And that just gives context to my vote. I'm not saying that that's any sort of weight on the way that you determine how you would try these facts.
Well, in response, I just say, in order to convict anybody on any of these items, the state's attorney would have to prove the case beyond a reasonable doubt. So I guess what you're saying is some of these items that are recorded, it's going to be easier to prove. A lease is not recorded. A check is not recorded. An entry in an account book or ledger is not recorded. A promissory note is not recorded. It just is more difficult for the state's attorney, and they're going to have to overcome their burden of proving beyond a reasonable doubt that the person violated the law.
Absolutely.
Half the list is and half the list isn't. Half the list is not. I get it. All right, so there's been a motion. What do you all want to do? There's been a motion, it's been a favorable. So it looks like we're gonna roll call the.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Pass.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
Yes.
Senator James.
Yes.
Senator Henson.
No.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Senator Sidnor.
I almost want to ask one more question. I mean, because, and again, I'm listening to what was said. Senator West, in your example, you said that the person was, I guess, arrested. They're going back into the house, so they were
Convicted.
So there was something that they could do. So I mean, they were prosecuted because they violated a law that was already on the books. So it's like, we're creating multiple. This thing cross out.
I'm the one that told you about the case. They were convicted, and as soon as they were released from their first offense, they went back into the house and are now re-squatting, if you will. And the case was just left like that, so we're all left hanging about
What's next?
are they going to come back and remove the person again? Just so you know the facts.
All right.
Not that it decides your vote here. at all.
I'll say yes. Reluctantly, I'll say yes.
But it doesn't even have anything to do with the lease. I don't even think they're not even claiming a lease. They're
All right, the bill as amended passes 10 to 1. All right, Josh, we're now on to Senate Bill 87.
Senate Bill 87 is a departmental bill that repeals the requirement that the photograph included on an identification card, driver's license, or moped operator's permit issued by the MVA be in color.
There's been a motion for a favorable. It's been seconded. Do we need a roll call, or is everyone okay being recorded in the affirmative? All right, Senate Bill 87 passes unanimously. All right, Senate Bill 97, that's withdrawn, so we'll wait, we'll hold on that.
You
we-
can just WDR it, withdrawn.
withdrawn unfavorable. Is
It's
motions?
not unfavorable
and
anymore,
with-
they changed.
All right, the motion is now not withdrawn favorable, it's just withdrawn, so it's withdrawn. Is there a second? All right, is everyone okay being recorded in the affirmative? Okay, thanks. That's what we're trying to do. All right. Senate Bill 125.
Senate Bill 125 is a departmental bill that repeals the requirement that a notarized bill of sale be submitted to the MVA, which applies when a person transfers ownership of certain used vehicles.
Is anyone, so there's been a motion for favorable and seconded. Is everyone okay? Is for discussion? All right, is everyone okay being recorded in the affirmative? Yes. Okay. Senate Bill 125 passes unanimously. All right, we're now going to go to Senate Bill 145.
Senate Bill 145 authorizes an individual who is the sole owner of a vessel or multiple individuals who are co-owners of a vessel to designate a beneficiary to take ownership of the vessel on the death of the sole owner or the last surviving co-owner outside of estate administration, and multiple individuals who are co-owners of a motor vehicle to do the same.
Senator West, why'd you bring the bill?
Actually, it was one of the bills brought to me by the Estates and Trust section, and I looked at it and I said, I thought it was a good idea. We currently allow savings accounts, checking accounts, residences to be in joint names, so they won't go through probate. They'll automatically vest in the benefit in the survivor or the designated beneficiary. We should do the same for motor vehicles and vessels. That's the deal.
What we actually do for motor vehicles, this would add vessels to the same statutory scheme.
All right, no amendments. Motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, we'll now move on to Senate Bill 149.
Senate Bill 149 is a departmental bill that alters the requirements for regulations related to the issuance of heavyweight port corridor permits by the SHA. Under the existing statute, travel routes for these permits must be established formally through regulations. Under the bill, the Secretary of Transportation must establish the authorized destinations for the permits, while travel routes for the vehicles must be identified directly on the permit rather than in the regulations themselves.
I just thought, not fine. Yeah, so there's motions for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 149 passes unanimously.
The next three bills are all withdrawn.
All right, we can do this. Can we do it en masse?
WDR.
Yeah, all
Yeah,
right.
just do it all
All
together.
right, so Senate Bill 175, 210, and 220 are all, the motion is withdrawn. Can I get a second? Is everyone okay being recorded in the favorable for the withdrawn? All right, so 175, 210, and 220 are withdrawn. All right, Senate Bill 221.
Senate Bill 221 prohibits a person from violating specified child pornography-related prohibitions under the criminal law article with 100 or more images. The bill also prohibits a person from violating 11207A4 or 11208B1 or 2 of the criminal law article with any image depicting a minor or other individual indistinguishable from an actual and identifiable child under the age of 13. Violators are guilty of a felony punishable by imprisonment for up to 10 years. A sentence imposed is may be separate from and consecutive to or concurrent with any other sentence imposed by a court for another crime based on the acts establishing a violation of 11207 or 11208 of the criminal law article. This legislation is similar to legislation that the committee has previously passed. This was Senate Bill 545 of 2025. Actually, no, it's marked as identical.
Yeah.
Yeah.
All right. Okay. There's motions for favorable, it's been seconded, is just opening it for discussion, is everyone okay? Significant bill, pretty good bill, but just, all right, everyone's cool? All right, so Senate Bill 221 passes unanimously. We'll now move on to Senate Bill 252.
Senate Bill 252 increases the number of members on the Board of Directors of the Maryland Legal Services Corporation and makes related changes. Specifically, the bill increases from 9 to 12 the number of voting members, from 5 to 7 the number of voting members who must be lawyers admitted to the bar in the state, and from 4 to 5 the voting members who must be non-lawyers, and from 7 to 9 the number of voting members required to remove a voting member.
I like this bill, it's a good bill. Motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Oh, sorry. Okay. So Senator Fulton is down on 252. The bill passes 10-1. Excellent. No worries.
I'm always trifling.
All right. We're now going to go on to Senate Bill 298. Just while he's queuing this up.
Sorry, go ahead. Senate Bill 298 alters and expands the jurisdiction of the Department of General Services, Maryland Capitol Police. The bill takes effect July 1st, 2026. Under the bill, repeals DGS's jurisdiction over and full police authority for the enforcement of criminal laws, parking and motor vehicle laws as to the operation, maintenance, and protection of buildings and grounds administered by Annapolis Public Buildings and grounds extending and surrounding an area that encompasses 1,000 feet from the boundary of those buildings and grounds, as well as other areas in the current statute. Instead, the bill establishes that DGS has statewide jurisdiction over and full police authority for the enforcement of criminal laws and the parking and motor vehicle laws as to the operation and maintenance and protection of, 1, state-owned and state-leased buildings and grounds, and extending to surrounding areas that encompass 2,000 feet in any direction from the boundary of those buildings, and 2, other public improvements or grounds designated by law or by BPW.
Move favorable.
Hold on. Okay. All right, it's favorable second. We're going to discussion. Yeah.
I have a quick
Senator Love,
question
yeah.
for council, if I may. Thank you, Mr. Chair. That last bit, they have authority. Can you just read that again, please?
Sure. The entirety of it is that the bill establishes DGS has statewide jurisdiction and full police authority for enforcement of criminal laws, parking and motor vehicle laws, as to the operation, maintenance, and protection of state-owned or state-leased buildings and grounds, and extending to the surrounding area that encompasses 2,000 feet in any direction from those buildings, as well as any other public improvements or grounds designated by law or by BPW. Now, the 2,000-foot buffer that I was describing applies to the area that is around those state-owned or leased buildings, but the exercise of the jurisdiction is statewide. So my read of that is that there could be an incident that occurs in a state-owned or leased building or within 2,000 feet of it, and I'm wondering if maybe this is where the question was, but the enforcement of the law and their exercise of authority over a person for violating it is throughout the state, not just within the 2,000 feet.
Right. My question was the second part of that.
Oh, sure.
It seems it's very open. Any other authority given to them by BPW?
Correct.
Have we ever done that before?
I was speaking with a representative from Department of General Services earlier. There is evidently a provision in the transportation article that grants similar authority for MTA police to have their jurisdiction augmented by either the administrator of MBA or, I believe it's MBA, or the governor. So it can be authorized by an official effectively unilaterally. I can look more into that if you'd like, though.
Thank you. Thank you, Mr. Chair.
Yeah, I mean, I have no problem. I like the bill. I just want to make sure everyone knows what they're voting on about it, because it's, you know, the jurisdiction is going to be expansive, which is on one hand, it's, you know, it'll be the broadest jurisdictional scope of any police agency in the state, including MSP. On the other hand, it can act as a force multiplier for local jurisdictions that are suffering from recruitment issues and things like that. So, you know, critical incidents and all, you can kind of plus up. So, I mean, I want to make sure everyone just understands what we're voting on, because it's significant. But Senator Fulton, yeah.
I mean, I was just going to point out that it's, like you said, a force multiplier, and it's really for critical incidents, but it also allows them the authority. There's such a gap right now for the U.S. Capitol Police to be able to go and investigate some type of complaint outside of what's being alleged to have happened here. You know, they can't, their jurisdiction it would prohibit them currently if I'm to go and investigate or interview somebody who is harassing one of the legislators or something to that effect. Kind of what we just recently have experienced, one of our legislators being stalked online. That has to go through state police, because even though it's coming into his office email address, they're prohibited from that. The other component of this, which is really an important part, is if, like when we had the active shooter incident the other year, should something like that happen relative to where they are right now, they would be really restricted, even though they're statewide. They all attend the same police academy, the same training. So I want to be clear on that. It's just like the school police. They all have to meet the same guidelines, same in-service, but it restricts them on their ability to supplement in critical incidents to be that force multiplier.
There's a motion on the floor.
I train them and then let them sit idle.
Can we, it's been favorable, it's been seconded.
Can we go back to Senator Love's question? What was the policy reason that they gave for the BPW portion? Or was that just simply taken from another section of code?
Because I'm sorry, because I meant to bring that up. So like MTA, they're a good example of that they'll go and they'll leave the bridge when they used to patrol certain areas, and they'll ride all the way out to the MARC station in Brunswick. And that whole area in between, they're still, because they're hitting these remote locations, they're still given statewide authority in the event that they come across some type of egregious criminal behavior or to be a force multiplier. But they go and and that's the authority that's given through the administrator. So they're a similar body that normally only have very pocketed enforcement or, you know, law enforcement responsibilities, but giving them the opportunity to also, in the event, as a force multiplier, should something occur.
Yeah, thank you, Mr. Chairman. For the record, Chief Chaudhry, Secretary of Maryland Department of General Services. The board, segment in question for Board of Public Works, that's existing law. So that's currently existing law, where it says that, where I believe it is 4601 A2 indicates other public improvements or grounds designated by a law or by the Board of Public Works. And I think that typically relates to any Board of Public Works improvements or buildings or anything else that's added to the state's portfolio traditionally. So that is that. And then just to clarify the bill, it gives full law enforcement jurisdiction to 2,000 feet. And anything beyond that, the amendments to the bill require advanced notification to Maryland State Police and advanced notification to any local law enforcement that will be operating in the area. So we'd have two layers of notification, one mandatory to state police under the amendment and one to local law enforcement, and then unless there's an emergency or exigent circumstances. Yes. We submitted amendments, right?
No, we submitted it.
We don't have amendments.
We have not submitted amendments? Okay. Yep. Okay. Apologies, thank you.
All right, we're going to table Senate Bill 298, and we're going to move on to Shamari with Senate Bill 314.
Senate Bill 314 establishes a limitation on liability regarding the donation of pet items, including commercial feed, that mirror existing provisions regarding the donation of food. Specifically, unless the act or omission amounts to gross negligence or willful and wanton misconduct, a person may not be held civilly liable for any act or omission that affects the nature, age, condition, or packaging of a donated pet item if the person in good faith donated the item for use or distribution by or dispensed the item on behalf of a nonprofit, corporation, organization, or association or a unit of state or local government. In addition, the bill authorizes the Maryland Department of Agriculture to inspect for wholesomeness any commercial feed donated to a nonprofit corporation, organization, or association, and establishes procedures for handling commercial feed donated to any nonprofit, corporation, organization, or association.
Second.
So motion for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 314.
Did you get them?
Senate Bill 314 passes unanimously. We'll now move on to, actually, this one's good. Let's just go to Senate Bill 404 has been withdrawn, so the motion is withdrawn. Is there a second? Second, thanks. Is everybody okay being recorded in the affirmative? Great. This Senate Bill 332.
That was the bill.
I like this bill, but it's a complicated bill. And there's been a request to hold it, so we'll hold till the next voting session.
Okay.
Now we're back to Senate Bill 298. So can you explain the amendment, the purpose, and then, yeah, we'll explain, and then I have a question.
Yep, sure. Thank you, Mr. Chairman. Again, for the record, Chief Charter Secretary of the Maryland Department of General Services. So the amendment we've vetted through and coordinated with Maryland State Police on requires advanced notification going outside that 2,000-foot radius. We would provide advanced notification to Maryland State Police and coordinate with them. And then also the amendment, I believe, removes the word public officials from page 3 of the document as well. Because we felt as though it captured both under people and property it was redundant. It captured it all in there as well. Exactly. So, and I believe we also have a letter submitted from Colonel Jackson from Maryland State Police in support of the bill with amendments.
All right, let's the motion's to adopt the amendment. Second, everyone has it before them. All right, so now the bill is before you as amended. So a motion for favorable, it's been seconded. Are there any, is everyone okay being recorded in the affirmative? Yes. All right, Senate Bill 298 with the amendment passes unanimously. I believe that is the end of the voting list. Have a good evening, everyone. Thanks. Sign it, yeah, hold on, I'll gavel out in them. Yep.